to welcome you to the weekly BW Legal World podcast, webcast, webinar, conversation, whatever you may want to call, to discuss issues at the intersection of business and legal. Today, we're taking a topical issue. We are discussing the new government guidelines on OTT. We're discussing whether what will the government achieve from these new rules. Are these new guidelines a speed breaker to the thriving and growing OTT industry? And also, why was self-regulation not enough? Because there was a self-regulation code that was brought in by the OTT players themselves. We look at the legal issues, we look at business issues, and we look at viewer and consumer issues. We have to approach it holistically. We are Businessworld and BW Legal World. To give us their perspective, we have experts, people who have first-hand knowledge and are involved in this ecosystem. They'll be able to guide us through this discussion and give valuable input. Let me introduce our panel. Today afternoon, we have Mr. Zamir Nathani, who's the General Counsel of UFO Movies. He understands technology, media, content. They're a leading technology solution provider to the broadcasting or a narrowcasting or a multicasting industry, traditionally digital cinema, but much more than that. Welcome, Zamir, to the conversation. We also have Ms. Tanu Banerjee, who's a partner with Khaitan, and welcome, Tanu. We also have Mr. Vishnumohan Rethinam. Welcome, Vishnu. Mr. Vishnumohan Rethinam is the partner in Remfry and Sagar, again, a leading IP law firm. We also have Ms. Anamika Jha, who's a legal officer for the Screenwriters Association, and she's the founder for Taurani for creators. We have Ms. Petal, who's a partner at Trust Legal, and they have media clients and they have first-hand knowledge of what's happening in this domain. And last but not the least, I have Mr. Karan, Taurani, who's a vice president and a research analyst in Elara Capital, somebody I lean on from time to time to get very nuanced viewpoint on media. I get his reports. So Karan will bring an overall perspective and not just a legal perspective to the domain. I'm also joined by two of my editorial colleagues, Ms. Anisha, Aditya, who is a senior editorial consultant with BW Businessworld. She helped us start BW Legal World and is now launching our VC and private equity community this week called VC World, which she worked on for 3 months. And Mr. Krishnendra Joshi, who is our editorial lead on BW Legal World. He is the pillar and the backbone of the editorial at BW Legal World. Let me start by inviting Mr. Nathani, who's the General Counsel at UFO Movies, for his opening comments on this legislation and what does the government wish to achieve through this.
Thank you, everyone, and welcome all to this fabulous BW Legal World, which has been organized. I think it's one of the holistic program on the IT rules which I've seen. My opening comments on OTT platform and the new IT rules which the government has brought in is divided into 3 parts. Number one, the first debate started with having censorship for OTT platforms and the resistance thereto. This was in the early phase of the pandemic when we were there. The second debate which started were with the cases in UP, ultimately the Chandok case which came in Supreme Court of India, where Supreme Court categorically stated freedom of expression is subject to reasonable restrictions. The third debate started when the government came out with the regulations on OTT and social media, as it was not only a content issue for OTT, but there were also issues relating to misleading news, which was affecting governance, etc., and everything was covered under that umbrella. Having gone through these 3 phases, we had the next stage which came up was the Kerala High Court order, which said no coercive action to be taken under the rules. And then in the further hearing of Supreme Court of India, in the Chandok case itself, the Supreme Court said that, these guidelines have no tooth and there are lack of provisions for prosecution in case of violation, etc. And there are no effective mechanism to screen the content, wherein the Solicitor General, Mr. Tushar Mehta, said that, the government will consider appropriate steps, any regulation on digital platform, and the revised regulations will be placed before the court. So this is where we are from yesterday till today. where this debate started. According to me, the regulation is only a test mechanism because there are 2-3 criteria you have to evaluate. Number one, do you need to regulate in a adequate manner where it is balanced on both sides? Number two, whether you have to balance it together with the substantive law. So my further questions which will come up, I'll clarify that when you have a substantive law like Information Technology Act, Copyright Act, etc., your substantive law will be your first door of entry and then will be your regulation. And third is that you have international conventions in United Nations like Berne Conventions on copyright, etc., and the international FDI and business scenario. So, I see there is a balancing act which is happening. And I think that is why the government is also testing guidelines, keeping the balance between the business as well as the governance business of the government. That's my opening remark. Thank you very much.
Thank you so much. Let me bring in Ms. Tanu Banerjee for her opening remarks. Tanu, your opening remarks, you'll have to unmute yourself.
Thanks, Annurag, and pleasure to be here with such a stellar panel today. Just in terms of, I'll keep my opening remarks brief so that, everyone has enough time. I think the precursor to these IT rules was, like Zamir pointed out also, that the whole debate in the industry started with these multiple PILs being filed across the country, by different users. And some of them were obviously contesting and disputing how and the kind of content is being shown on these platforms. Now, of course, India is a very, very wide and a peculiar territory in that sense, with different sensibilities and different cultural divides. So there is always going to be a difference of opinion there. But stemming from those PILs, I think the government has constantly been pushing all of these platforms to come together and have some sort of vigilance framework around the functioning of these platforms. And post that, I think, under the aegis of IMAIS, we would all know, I think a lot of these players had come together and IMAI was, performing a crucial role in sort of coming together with a code of best practices, as it was called. And there were two versions to it that came in. The first version, I think there was divide amongst the players themselves and it sort of didn't work. And then everybody came together and revisited it and came up with a second version, right? And now it seems that, the government perhaps wanted it to be pushed a little further and wasn't completely satisfied with what the players had discussed and come up with amongst themselves in terms of best practices or the self-regulatory code that it's called. And from there, of course, I think there were multiple discussions, consultations. The government was trying to come up with something, and now we, of course, have these IT rules. In terms of where it stands today, I think, while I think that it's not a surprise, it's not something that the government just came up with one fine day. It was always burning. It was in process. But is it completely holistic at the moment? Perhaps not. It definitely has open ends to it. It definitely has loopholes. It has subjective parameters. And perhaps at the moment, it doesn't cater to a lot of different platforms which unintentionally come within its purview. And that needs, certain a little more thought and fine-tuning overall in terms of the legislation. And we'll, of course, along the next 1 hour, go to look at some of those details. That will need.
Vishnu, your opening comments.
Thank you very much, Annurag, and it's wonderful to spend an hour on a Saturday afternoon in the company of fellow professionals. Very good to meet Karan and Zamir, who are slightly off the beaten path compared to Petal, Anamika, Tanu and I, who are more on the consulting line. To be very honest, my experience stems more on the consulting practice, actually. I'm not really, the regulations are new, their effectiveness or efficacy is also very, very new. The government is, currently asking people to inform them if they've started complying with the guidelines that were notified in February earlier this year. But Zamir and Tanu have adequately covered the path leading to where we are today, including the cases, what the Supreme Court has commented, and perhaps this level of uncertainty on whether these will be effective or not. For me, and I must clarify that I'm not a member of any party or whatever, but I feel that the government has thematically, perhaps substantively at some level, got the mix okay. I won't say it's brilliant, but it's right to start with. But I can't help but perceive some level of excessive bureaucracy, technocracy, and too many cooks spoiling the broth insofar as the grievance mechanism is concerned, especially when it gets to the government. When it gets to the oversight mechanism, I'm a bit concerned. I think that you'll have too many voices. I think that thematically, insofar as the grievance is concerned at the earlier levels, it's okay. But when it comes to the oversight mechanism, I'm a bit concerned, and I hope the coming months will shed some light on how things will run, and I hope it just doesn't get passed like files between various government offices and getting stuck, literally in a rut. So with that, I will pass on, and I think I will address these concerns with reference to the questions to be put later on in a bit more detail. And I'm happy to pass the buck along to whoever is next.
Thank you so much, Vishnu. Let me bring in Anamika. Anamika, your opening comments.
Thank you, Mr. Batra, and thank you to meet all the eminent panels here and wonderful people who have joined us in this webinar. So my opening comment will be there was requirement of regulation that none of us deny, because OTT platform is exponentially growing and there is loophole in the regulatory mechanism. And when there is a loophole, it is subject to some misuse, and as we see it in the Harshad Mehta case as well, there was some loophole in the banking system and therefore scam happened. So regulation is required. But what is contested here, the manner of the regulation as well as the manner in which the government came to that document of the regulation. So yes, when we see the regulation, there are few welcome steps, the classic age classification of the content. We know that all content are not good for a specific age group, specific people. So there should be the classification. At the same time, it is required to have some content descriptor as well, because some people might not be very comfortable in watching sexual abuse scenes or drug abuse scene, and that might have an impact on them. So these are the good things. But at the same time, the regulatory mechanism, this oversight mechanism, which as other panelist has also pointed out, that it may have some executive overreach as well. And once the document, the government come to this regulation, they said that yes, there was a round of consultation, but I think that there was requirement of the consultation from other stakeholder as well. For example, audience, they are also the stakeholder in all this debate. They should have their own choice to come up that whether this regulation is good for them or not. What are their suggestions in that? As well as industry experts, their opinion and open opinion, which each of us can read, should be taken before bringing this landscape change in the OTT mechanism. So in the coming 1 hour, of course, we are going to discuss it in detail, but this is my opening comment.
Thank you so much. You clearly have brought out the point of classification of content, children being exposed to content that one should be. And, Siddharth Roy Kapoor, when there was an interaction with the IND Secretary, Mr. Khare, he said there should be soft touch because anyway, this kind of content is available to Indian audiences from across the world. So really, we need to be mindful of that. Let me bring in Ms. Petal and your Petal, your opening comments.
Thank you so much, Dr. Batra, and good morning, everyone. Pleasure to be part of the panel. I think most of us have actually covered what exactly we are going to discuss and different facets of the discussion today. I also have a similar view as Anamika's that, there are so many facets of what we see on the OTT platform. And of course, we have the right to whether we want to choose to watch it or not, because they are all subscription based. But at the same time, some sort of a regulation which can really control the platform is something that is the need of the hour. Yes, implementing it is going to be another ballgame altogether. I think as we go forward, we will see how things are going to actually go on ground. Definitely, this is something that we are looking at from a positive aspect also. And another thing which I'm going to close with is that even though there is a there is a 3-tier legal framework how to actually go about in this under this regulation if there is any concern or any issue which arises, but everything is going to boil down to it being politically governed or politically controlled. So whether whether it's a regulatory controlled mechanism or a politically controlled mechanism is actually also something that probably we can look into and maybe see in the future in coming times. Yes.
Thank you so much, Petal. Karan, finally your view, and you're the non-lawyer on the broadcast. So even Anisha is a lawyer, and so is Krishnan. You and me are the only non-lawyers on this panel. So Karan, your view.
Right. Thanks, Annurag ji. Can you hear me now? Yeah. Thanks, Annurag ji. Hi to all the panelists. It's a pleasure to be in this session and share my views on the industry impact basis, the regulations, what have been coming in. A lot of the points obviously have been covered, but 2-3 things that I like to bring in perspective here. That if you look at the global markets, there is always some kind of regulation, some kind of restriction. So except for the markets like US and UK, which are primarily mature markets and primarily the mirror in terms of the Western markets world, there is a regulation, there is some kind of interference in every country, be it Indonesia, China, Singapore, Korea, Saudi, wherever it is, right? So I think this kind of a thing is needed in a country like India, wherein we've got diverse cultures. So it's a very good thing that it has come in, and it's come in to protect the society, it's come in to protect the children from watching content which is not suitable for them. So I'm not in favor that this thing should go towards a blanket censorship, because that too doesn't augur well. It's not fair to go towards a blanket censorship. I think self-regulation is the key, but through this panel and going ahead also, we need to really dig deep in terms of how the self-regulation code will actually work. One important aspect of this is the penalties, right? So what are the kind of penalties one were to impose if someone actually does wrong or probably portrays a wrong amount of content? So I think this is something which we need to get more clarity from the government. But the regulation code is good, it's healthy for a market like India. Also, one thing is, I would not like to point out here, but just from an industry perspective, I think it's a very good level playing field for TV. Because what you were seeing from all these years is that you saw a big shift of eyeballs, from TV to digital, wherein TV was completely censored and digital was completely uncensored, right? So that's not fair. So I think just to put that thing also into perspective, I think it's a very fair point that it's going to bring some kind of level playing field between TV and internet. Lastly, but not the least, but in terms of content, controversies have always been there. So we've seen the case of film like a Padmavat, which was kind of opposed by some sections of the society. It was banned in certain states. All these things we have been seeing in the past. It is just that with the advent of OTT, too much of content is being consumed, and because of this too much of content, there is a higher probability of something wrong coming or something hurting someone's sentiment. So that's my initial remark on this.
Thank you so much. Now let me get. I think all of you brought on the need for this. And also the caution that we don't overstep. And then let's dive into nuances. My first question, and let me post this to Vishnu and Tanu. What does compliance for OTT platforms look like under the new rules? Are there any gray areas? And how can these gray areas harm the OTT players? First Vishnu and then Tanu.
Okay, like I said in the opening remarks, for me, the compliance looks okay at this point of time insofar as publishers go and insofar as self-regulating bodies go. IMAI and IBF may generally not find it an onerous task to ensure compliance. If you look at the IMAI Universal Self-Regulating Code, it's thematically in line. It just needs to align itself procedurally and in terms of specifics with the MEC. Insofar as the IBF is concerned, they have a wonderful history of actually being in these shoes insofar as traditional broadcasting is concerned. So they already have a very strong foothold. They have an issue of preeminence insofar as the subject is concerned. They have a lot of judicial heritage in that setup. Now, for me, again, it's basically insofar as the working of the grievance mechanism at the oversight level that is a point of concern. It's a very serious point of concern. There is just too many cooks there. there is an oversight of an oversight. Look at the secretary stepping in, and then you have the joint secretary who can again put a secretary's views back to the committee and then have a disagreement, and then you have the review committee under the Telegraph Act coming in. I mean, I'm not sure where that is headed at all. That for me, in terms of adjudication of orders and then further compliance, will be a problem. If you look at the IMEI code, there are very specific issues on fines and all. They seem to be very reasonable. But insofar as the DMEC, that's a little gray area for me. And again,
but in some way, the government did not accept that code, and that's why they brought in their own code. And again, there are gray areas.
I understand. So the point for me is that there's a lack of engagement. I mean, if the engagement, for example, I think the IMEI code is thematically there, but I think somewhere there's a lacunae in terms of engagement. And if that engagement had been a bit more thorough, perhaps you would have had more specific, clear-cut guidelines at the oversight level and in terms of implementation level. And otherwise, I don't see any major issues. I mean, Tanu can highlight if she feels there are.
Any gray areas that can be misused or can backfire?
So Annurag, I want to break this into a couple of things. And, like Vishnu said in the beginning, we are more on the consulting side. And in the course of our practice, what happens is that we end up seeing, a wide band of people who are affected by this, who may not necessarily be just content platforms. And obviously the intent is to regulate, these content platforms. I think in terms of compliance, there are two buckets to compliance here. One is the code of ethics, which is focused around content. And there I think of course there are parameters which are subjective, but those subjective parameters sort of have been, within our legislative framework even earlier. So I think that is a little bit of an extension in terms of age descriptors and, disclaimers, etc. Those are practices that have been followed internationally. And I think that part of it is okay. What I'm more concerned about is the compliances which is at the entity or the platform level, right? One critical thing that the court says now is to appoint a grievance officer for all of these platforms. And while it may not be challenged for some platforms who are sort of already set up in India, but India in that sense has been a space where platforms, even that are owned by offshore entities or international players, have been able to operate in India. For them today, it is a little bit of a challenge, and people are trying to evaluate how to comply on that aspect. The other thing I think is a little bit of a miss in the legislation right now is just how these platforms are defined and how content itself is defined. So there are various new definitions in the rules. On demand, online content online curated content, publishers of online curated content, publishers of news and current affairs, news aggregators. Right, these are all definitions which were not existing in our previous legislation and have just come about. And I think what it ends up doing, and I would keep this discussion narrowed down to the extent of the content platforms, OCCs as we call them, is that while obviously the intent is to govern platforms in the category of entertainment contents, let's say a Disney or Hotstar or a Netflix or an Amazon, but what has unintentionally happened is because the definition of online curated content simply says audiovisual content. And today, because of that, there is content and there is video content on a lot of different kinds of platforms. Today, e-commerce websites have, videos which cater to the video commerce market. There are health applications which have content which is perhaps, consultative and medical in nature. What are we doing? They're obviously primarily not meant to be for entertainment. But are they outside the purview of this legislation? They're not. And does it now make sense to extend all of these compliances of having a 3-tier grievance mechanism, being part of a self-regulatory body, creating descriptors, compliances around content? What do these platforms do? Right? Because the primary purpose of these platforms is not entertainment or not to publish content, so to say. But content becomes an ancillary function of these platforms, right? So, perhaps a little different perspective here. But practically, I think that's it's something that affects everybody in the ecosystem, and that ecosystem is not limited to only entertainment. It expands, right? That's where my inputs would be on this.
Thank you, Petal. Your comments.
Sorry, Annurag.
Yeah, go ahead.
Sorry, Annurag. Tanu, the fact that these e-commerce platforms dealing with pharmacies, Amazons and all, they're all members of IMAI, etc. Do you think that brings them automatically within the purview of this legislation, and therefore does that solve the problem? I mean, sorry, this is a sidebar. I've been grappling with this question myself in office while advising. I'd welcome anyone's views. Sorry, Annurag.
Absolutely, Vishnu. I think some of them would automatically, because given that they're functioning from a larger and a broader ecosystem. But then there are also smaller players who are, their targeted business is just that, right? Video commerce industry, for example, is really big outside internationally, and it's maybe just, starting off in India. But at the moment, whenever it comes up, a platform that is just specifically catering to the commerce industry and therefore has video content and created video content, and some of them may engage in similar fashion the way content industry engages with celebrities, with influencers, with talents and all of that. But the purpose is very different, right? So I would think that compliance of this level for those categories is very, very difficult. At the moment, for example, like you mentioned, Vishnu, the ministry has asked all of these platforms and players to furnish information. Some of those players are really grappling because they don't know what to do. At the moment, are they hit by it? Are they not hit by it? Should they clarify with the government, right? So it's a slightly different perspective on this overall.
Agreed. There is gray in it.
That's what I was addressing in my question, Petal. What do you think now? How do you see that? One of the stated objectives of the policy, and even in the conversation with the industry, the INB secretary pointed out that one of the key reasons for the regulation was to ensure that parental locks are implemented for content that is not appropriate for children. Will this be available with the new rules? How do the new rules go about dealing with the issue of child pornography?
Dr. Batra, definitely, I think the regulations intent is to actually control these extreme, content which can have a major impact on, say, children, on the youth, because what we see is actually what actually ripples in the society. So, you see a particular content, or you see your favorite star doing something. When I'm talking about the youth, it's about teenagers. And they will follow a particular thing or that kind of, behavior and attitude in society itself. So I think the larger perspective has definitely been to control, in a way, to actually regulate this entire, mechanism by way of which the society is also going to transform at some stage. So definitely, when we see that these regulations have been introduced and things like parental locks, and when we are talking about pornography, when you're talking about abuse, sexual abuse, and things like that, definitely I feel these regulations will play a very important role. The aspect of self-regulation, I think this will also enable all the platforms, all the OTT platforms, to actually have an abundant caution at their own stage. So I know some of my clients who are particularly not OTT, but they're a mix of OTT and some kind of app. And what they're doing is they want to, as an abundant caution, put more and more compliances, so that they don't come under the purview of any sort of violation. So I think with these regulations coming in today's times, will also enable all the players to be a little bit in sync with what the regulations say, and also take some sort of abundant caution, like setting up their own internal grievance redressals, etc. I think that will really help. But yes, I think what Tanu is also mentioning is that there are a lot of smaller players who probably it'll be very difficult for them to really adopt these regulations and steps. But I think as we move forward and as we go ahead, I'm sure they will also fall in line. and this thing will definitely fall into place to become a more compliant and acceptable sort of a platform for everyone.
Thank you so much. My last question before I bring in Anisha into the conversation, and she will take the next set of questions with you. This is specifically to Anamika, Karan, and Zamir. There has been a censorship debate. What is the right balance? The very premise behind the creation of OTT platforms was to offer audiences original and diverse content that is not regulated by any government body. What would you say to those voices? Some voices feel that the new rules are behind the, they're not in the spirit of, free speech. Of course, the judgment said that it has to have self-regulation. Some people believe in the industry that the new rules kill creativity, and the choice is for the consumer. As long as disclaimers are there, it should be good enough. So what do you have to say that? First Anamika, then Karan, and then Zahir.
So when this government announced that they are going to bring OTT rules, most of my clients, writers who are actually the first level of content creator, they came up with the queries that, oh God, then we have to do the self-censorship. Like when I'm writing, I want this complete creativity, because when OTT platform came into picture, it brought a huge creativity among the writers and all, because initially they had two options, either to go for theater or to go for television content. Theater, there is the full-fledged censorship, which is highly debated and contested. And on TV, of course, you cannot show all kind of, you have to restrain yourself to specific kind of content. So OTT gave them a wing. Then is it they have to actually decrease their creativity, or is it going to impact it? So yes, at some extent it is going to impact. How it is going to impact, I can give a small example. See, the level, entry level, when is that, grievance which is defined in the rules is so vague, anything can be. If you are offended by anything, you can file a complaint. And on the first level, on the second level, as well as you go to the third level, if you are not satisfied at the first level and second level. What if the grievance is only politically driven and conforming with certain ideology? It is not in conflict with Article 9.2, but it is conflict with certain political ideology. Then there might come censorship, that content got blocked by the government. Because, for example, I being a Bihari get offended by a particular TV series which show Bihar in bad light, in my opinion. I will go to the grievance redressal. Until unless they don't remove the content, I don't get satisfied. I go to the next level, to the ministry level. And suppose the Bihar election is coming on. So minister will think from that point of view also, not to offend.
Yeah, these are real issues.
Yeah, real issues. So then what happened? I have to, even if showing Bihar, even if it is a factual basis that there was some political misplacement in the picture, but then there might be a case of censorship, which the OTT or which the even writers or which the all people engaged in this creative process has to have comply with. So I may say that this what I brought in the opening comment as well, this direct ministry overreach or this oversight, you may say, for everything without defining any threshold is going to be a problem. See, if there is any grave issue which demands immediate attention, there is a provision in the Cable TV Act, there is a provision in other act where central government can intervene, but central government can intervene on anything and everything. This, I think, is going to hamper the creativity because it requires a judicial training and judicial mind to define whether it is in violation or not. A bureaucrat is defining and implementing all these things may have an impact on the creativity. But you can be more creative as well, like a Scam 1992 or Panchayat or TVF series. These series fit in this regulatory regime, but also it is very creative. So it has some impact, but again, you have to deal with it until it is here.
Karan, your point of view?
Yeah, so Annurag, basically there are three things which I would like to get on over here in terms of implications, of this entire order on OTT. I think the first big implication is that there's definitely going to be a change in terms of the creative minds, in terms of how they think for making the content. So earlier they were only making catchy content and violent content or maybe new type of content which is suited for the youth of the country today. But what this pandemic has actually done is that it has also got a lot of family doing binge watching, together on OTT. Now, of course, that part of audience is very low because ideally, if you look at binge watch, it's mostly happening only on mobile phones, and smart TV penetration in India numbers are phenomenally low. But that's the future. So I'm guessing that a lot of the content strategy will change. And just like you have TV as a device which is family viewing, eventually, who knows, 10 years down the line, even digital becomes a family viewing kind of a thing. So the content strategy will change, given these regulations which has come in. The second factor is that there will be a negative impact as well in terms of the large marquee shows getting launched. So in many countries, if you see there are some restrictions in terms of the type of content you showcase, and basis that there is a delay of these shows getting launched by global OTT companies like Amazon, Netflix put together. So if these regulations are more strict, or they kind of restrict some sort of content, or they probably bring in some sort of controversy, and if there's a delay in terms of launch, I think that will be a negative, because if there's a delay, then you're looking at piracy being a big negative impact. Because earlier piracy was rampant because you were not able to get the shows live over here. But now again there's a delay come of 7 days, 15 days, 21 days, whatever it is, piracy is going to have a big negative impact in terms of consumption for these global OTT companies. Last but not the least, the third big implication I believe is that this kind of a move, I mean, the way it is done and how things go ahead, it will stop further fragmentation. So I would not like to name any app here, but there have been multiple OTT apps which have only, relied very heavily on nude content, on violent content. That is primarily been their key target in terms of the nature of content being produced. Now, those content companies will either shut shop or kind of scale down, because if there are regulations coming in for that kind of content in specific domain, I think there'll be a threat, to their existence in terms of content cost. So these are three major implications I feel which will come down to the industry.
Thank you so much, Zamir. You have the final word in this before Anisha takes over the conversation.
Right. So I put this in a triangle shape. Number one, even before the regulation, I was heading legal for Balaji Telefilms Ekta Kapoor. And we had the movie Dirty Picture, and I had my time in the courts of law. We had serials like Jodha Akbar, where there was a controversy by Karni Sena, and I had to stay put and resolve that. So I think before the regulation mechanism also, we had the laws which were addressing that. You have IPC which addresses on obscenity, you have copyright law which addresses on your copyright infringement, etc. Now, once your regulation is in place, just listen to the remark of Justice Bhushan in the Tandav case, where he says, rules are in the nature of guidelines. It does not have any teeth, no power for prosecution, no mechanism to control violation. So, when you put this debate in place on both sides, then, you completely feel that your freedom of expression remains the same as it was yesterday. Coming from government's angle, government says that, we are concerned about the explicit content being exposed to the minds of, children. We are more concerned about the misleading hashtags or misleading news which are going into the public domain. So this is the triangle which I see. My view is always that every new platform which is introduced, like we had cable TV earlier, which came into India, we should have a grievance redressal mechanism which should be put in place, instead of just getting into a zone where we prosecute a person and put them behind the bars. I think that's the best thing what we can do, is to have a redressal mechanism internally, externally. And of course, the courts were still available. Even without this regulation, people were still lining up before the courts of law. And I think the government came out with the resolution because the courts were insisting government on the law. And I think regulation is just a test of it. So that's my view.
You would call it a framework, a guideline, a code of conduct, and not a law. It may be precursor to a law.
Absolutely.
Right.
Absolutely.
Okay.
That's what Justice Bhushan also expressed, that, the regulations are merely, these are just guidelines, are just rules. So this is just a precursor about it. That's my view.
Fantastic. Anisha, I would bring Anisha in. She understands content. She understands law. Anisha, why don't you take it forward from here?
Thank you so much, Dr. Batra. My first question will be on the self-regulatory bodies which are currently governing the OTT platforms. And as we know that in India today, there are two self-regulatory bodies. I would like to ask that are there, in the implementation of the IT rules, are there any confusions or are there any gray areas in implementing those rules? And would you have any suggestions in how the legislation which is governing these OTT platforms can be further improved?
Coming from the regulation point of view, I would just say that, so I made one observation in the sense what the Supreme Court said, that, rules are in the nature of guidelines. They do not have teeth. No power of prosecution has been provided. There's no mechanism to control violation. This was the statement when, the relief was granted from arrest to Aparna Purohit, who's Amazon Prime India's head, for portrayal of one of the highest dignitary in our country in the web series. According to me, there are rules for blocking information in case of emergency under the rules. And this gets covered under Section 69A of the Information Technology Act, where it is necessary and expedient and justifiable to block such information, as well as there are provisions to unblock the information from public access. That's point number one. Number two is that I want every one of us to just have this view that there was a joint meeting of 5-country ministerial and quintet of attorney general which took place. This was on 30th July 2019, and it was attended by attorney generals of United States, United Kingdom, Canada, Australia, and New Zealand. And they recorded a statement in terms of the regulation. So today we are seeing these regulations, and what is the balancing act which the government should try and address. They made a statement in their communique. We are concerned where companies deliberately design their system in a way that precludes any form of access to content, even in cases of most serious crimes. This approach puts citizens and society at risk with severely eroding a company's ability to identify and respond to the most harmful illegal content, such as child sexual exploitation, abuse, terrorist extreme material, foreign adversary attempt, abuse, so and so, undermining democratic values and institutions. That was one thing, and they have said many things. This is a shared challenge that requires urgent action by governments, industry, and civilized society, focused on reasonable proposal, respecting different perspective and based on core value. This was one of the submissions made. If you see the perspective which has been put forward, WhatsApp has filed a case in Delhi High Court. It's all in the news, public domain. Where WhatsApp has said that, when the originator of the originator's information which has been asked by the government is also violation of the privacy rights. Of course, they have cited Puttaswamy judgment, where privacy right has been also upheld as fundamental right. But the judgment also has some aspects which is covered when it comes to your security of the nation, etc. That has been put forward. According to me, this regulation, as I said before, is a precursor to thresh out, to debate, to test it in the court of law. Ultimately, it may culminate into a law. And number three, I feel that there would be three mechanisms. One would be a self-regulation mechanism internally, self-regulation mechanism externally in terms of the body, and a redressal mechanism before the ministry, like we have in the television industry. So this regulation basically is from that perspective. It has been debated, but I think to an extent, it will be again tested in the court of law. Freedom of expression and speech will remain. Reasonable restrictions will remain under the Constitution, as has been specifically said. But I think this will never be able to infringe the freedom of speech and expression. That's my point.
Thank you so much, Mr. Nathani. Ms. Tanu, we'll ask you the next question. Can we have your comments on how the legislations governing the OTT platforms in India can further improve?
Anisha, sorry, you were a bit faint. Could you repeat the question?
Yes, my question was, how can the legislations governing the OTT platforms in India be further improved?
See, I think, like I said, in my, previously what I was covering, I think there are many open-ended definitions, terminologies in the legislation right now, and in all parts of it, including the intermediary part of it, or the digital media or the publishers part of it that we are talking about right now. One, it needs very, very thorough reading and very thorough understanding of what the legislation is ending up covering, the entire gamut of it, right? While the intent is to, cover and govern specific kind of platforms, it seems to have gone ahead that. And that I think needs a lot of engagement with the stakeholders at different levels and different businesses who are getting hit by it, and to understand if the compliances that we are extending right now are really practically achievable or not. The second part to it is that if we just overall look at the rules in its current form, and Zamir has very rightly pointed out, of course, that this has come suddenly as a subordinate legislation in the form of rules. And some of the parameters and the compliance requirements, in fact, some of the substantive portions in the rules are something which are completely absent in the parent legislation under which the rules has come, right? Which was the IT Act. So in that sense, how much teeth do these rules have? Obviously, it's questionable. But given that practically it's not that the ministry is taking it lightly. They have issued notices to different players. They are asking for information. So it's not as if the government has just put in place something and doesn't want to do anything about it. It's very clear that they are out there and they do want to have a framework in place. Is the framework adequate right now? Is the framework effective right now? That I definitely have my doubts on it at the moment. I think it is too wide. There are compliances which are too sweeping at the moment, and that definitely needs a lot of engagement, a thorough reading, and a lot of fleshing out and categorizing of what kind of platform and what kind of entity needs to do what. Right? Everybody cannot be put in the same bucket. The third leg to this, from my perspective, would also be that a lot of these tenets which have come in the rules are something which were existing in the linear space, in the satellite television space, and that seems to have been extended to the digital world also. While at a personal level, I think that should there be no vigilance at all for the digital world? Perhaps the answer to that is there should be some framework, and that has been in the pipeline. It has come in. But extending exactly the same framework to the digital world, I think, is not effective. They're completely different formats of viewing. They cater to a different kind of audience. Television, for example, follows the appointment format, like we say. And perhaps because appointment format being that there is a specific slot for a specific content, and everybody comes up and watches it at the same time in the same household and different households across the jurisdiction and the territory. And therefore, because there is just one time and one slot, that content has to cater to different kinds of audiences of all age groups. So perhaps the amount of regulation that is there in that segment is necessary to a lot of extent. But should the same thing be extended to the online world? I think that needs a deeper dive into how the online world is working, how content is produced, is consumed, and there are a lot of data points at the back end, basis which these platforms work, and all of that needs thorough understanding at the government level also, the legislators level, to come up with these rules. Does it cause confusion right now? To my mind, yes. It causes a lot of confusion at the moment. There are bodies that we are setting up. There may be a framework to redress grievances. Some amount of self-regulation is retained. But ultimately, it would really depend on what is the approach of the ministry at the top. How much of it is enforced? How strict is the ministry? How are things being looked at? That I think would be key eventually to understand how these regulations.
Thank you so much. Our next question will be for Mr. Vishnu. So So as you know, there are around 17 OTT players who are currently signatories to the Universal Self-Regulatory Code with the Ministry of Information and Broadcasting. So can you talk to a little bit about the opportunities and challenges faced by this code?
Actually, I'll address your question in a slightly different tangent. For me, the code, the Universal Self-Regulatory Code that these 17 people have ascribed to as part of their membership of IMAI is not really the problem. The code seems to be fundamentally okay. It imposes, it categorizes and defines things pretty nicely. It ensures that there's a mechanism for grievance redressal. Of course, the government's code supersedes this because the government's code introduces the oversight mechanism. For me, the problem is that once you get to the oversight level, you have a minister, you have a secretary, a bureaucrat actually, potentially overruling a retired High Court or a Supreme Court judge who sits in the self-regulating body. So IMAI and IBEF both will have retired judges of extreme and immense preeminence whose judgments are not questionable actually, being oversighted by a bureaucrat, which I think there's a serious dichotomy. Insofar as challenges are concerned, there aren't, in my view, any ready-made challenges in the self-regulating code itself, because at the end of the day, the DMEC also specifies that publishers can become members of any organization. They can choose to become members of more than one. It is a given that publishers will become members of any organization that comes into this space from a self-regulatory perspective, because at the end of the day, everyone wants to have a slice of the pulse or a feel of the pulse in every self-regulatory body, because at the end of the day, agendas and common goals have to be pushed forward with the government. Engagement has to take place. So there is no real concern at that level. I don't see any major grounds of confusion except on the oversight thing. I will also slightly exaggerate what Tanu said, and I think she's absolutely right in that. The government has said that, look, these are the digital media ethics, these are the guidelines, these are the rules. We're calling them an ethics code, but we're giving them the denomination of rules, and we are giving them teeth under the IT Act. And this is what we want people to comply with. Now, if you read through that, if you try and flesh out a couple of the red tapeism aspects of it, one thing that really stands out is there's a code of practices and there's a charter. I mean, what are those? Who defines those? Are those additional compliances in addition to what the government wants the self-regulatory bodies to comply with? And if so, are they going to be more onerous, or are they just, on the side, they're just a little extra guidance on what to do in certain specific situations? I think that's going to be an area of confusion. The final challenge actually is going to be how to fit the courts into this. I mean, is there going to be a judicial oversight over the executive oversight, which already has an oversight over a semi-judicial oversight in terms of the chairperson? This is going to be a major challenge. I think the courts, and I'm aware that at some level the consultative process to the DMEC did involve, legal officers as well. The problem is that people rush to courts today, and they want relief for anything that they consider offensive. And Anamika says, for example, she comes from a particular state, so she considers certain content offensive. It has a certain pulse insofar as the political landscape is concerned, and therefore the courts may or may not grant relief. But the idea is that if you go to a court with a complaint and the court knows that you've already filed a complaint with the ministry, the court may then say that, look, let that happen first. Of course, that will bring the issues of delay in terms of litigation and, in terms of approaching a court for relief is concerned. But at some level, the challenge is to find a little melange of this entire ecosystem so that multiple proceedings don't go to, you can file complaints directly to the oversight mechanism if you want immediate relief, if you want content to be blocked. At the same time, if you approach a court, there's going to be confusion. So that's like a major challenge. I'm not so concerned about challenges of integration of the code of the self-regulatory bodies with the main code. It will just be the easiest task in the world for them to say, let's adopt the DMEC insofar as it contains content that is in addition to and does not derogate what we say. So, and that will probably resolve everything. If you look at the self-regulating codes, they're very clear. They try and amalgamate all the laws. They try and amalgamate sentiment. They try and amalgamate the heterogeneity that this country enjoys. They try and amalgamate existing rules, guidance, constitution as well. So there is a very holistic thought to the self-regulatory code. I don't see that per se as a challenge.
Thank you so much, Mr. Vishnu. I will ask one last question, which is an industry-focused question before we start the closing remarks. Mr. Taurani, this question would be for you. So as we know, the pandemic has led to a surge in the consumption of digital content. Do you think in the upcoming years, OTT platform can gain even more popularity than television in India? And how are you looking at its growth in the country?
Right. So if you look at the numbers here, clearly there is a potential for OTT to actually, go above TV in terms of reach. But I think we are still, 5 years away from that story because if you look at the penetration numbers, I think TV is close to about 70% and smartphone is about 40% and smart TV is about 10%. So very low in terms of numbers, but definitely there is a potential, for OTT to actually move ahead in terms of the number of eyeballs. I think what's going to happen as of now for the next 5 years is that TV and digital both will coexist because both have got a very different set of audience as of now. Both make very differentiated content. Both have got different kind of regulatory structures. One is completely censored and one has got some kind of interference because of this IMA guidelines, so to say. So I think both will definitely coexist because again the kind of audience, content, approach, everything is very, very different. So OTT is not a threat for TV as of now, but as things stand by, as I mentioned in my earlier remarks, that you'll probably even start seeing family type of content being made on OTT, and who knows, with higher smart TV penetration numbers, people could start watching OTT content just how they're watching TV right now, and as a family viewing concept. So if that were to remain, then definitely there is a threat for OTT overtaking a TV after 5 years.
Thank you so much. At this point, we'd like to close the webinar by very quick 30-second closing comments from each one of you. Let me first get in Petal Chandok. Petal, your closing comments. What comes out is that these are still work in progress, if I can say. These are guidelines, and as the judgment itself said, that it doesn't have teeth, but it will be backed by legislation and all the other laws that apply in terms of content and IT are applicable. So what do you think needs to happen from here on to be able to evolve a more balanced and specific framework? Ms. Petal Chandok?
Yes, so one is, of course, like we are hearing that OTT is going to, see a surge in the coming few years, and like we know, OTT doesn't have an appointment viewing. It does not have a fixed viewing. So I'm sure that in the coming future, like what Karan is also saying, that OTT will see a surge, and yes, television can see a threat. Now, coming from that perspective, when we see that that is going to happen, and OTT platform will be something which will be looked at at a larger scale when we talk about the population at large. So definitely, one is that when I said earlier also that maybe self-regulation is something that I think these players really need to look into their own internal mechanisms, how they can really comply with all the regulations in order to avoid some sort of violations. Having said that, being part of IBF or INAI and trying to also follow as much compliances as possible, so as to be away from violation, is I think something that may help all these players going forward. But like we said, what is going to happen at the ground is only something that we'll see in the coming future when and as and when it happens. So yes, hoping for the best, and we're all there. I mean, as consultants and as players, we're all there to really support the clients and all the OTT platforms. So yes, that would be my closing comment. Thank you, Mr. Batra.
Okay, your closing comment, Zamir, very quick.
So on my part, what I feel is that we had the same debate and discussion which happened during when cable TV came into India, and ultimately it converted into a law, Cable Television Network Act. I see a similar thing happening here, number one. Number two, we should avoid confusion of multiple bodies like IPRS and others we had for music rights. Number three, we should avoid multiple confusing court judgments like we had for royalty for performers on Copyright Act 2012, where there are two judgments on just a day difference and they are conflicting and we are undecided till 2021. Number four, there should be an internal company redressal mechanism, one body recognized by the government similar to Broadcasting Complaint Council, grievance redressal mechanism before the court, and it should have a similar SOPs like television. And I completely foresee a law in near or longer future, like cable TV, maybe merged or independent law. And these regulations are just to thresh out the debatable points before culminating into a law. That's my submission.
Okay, Anamika, your final comments.
So I believe yes, a full-fledged law is very important to have, which will remove all the confusion and lacuna which we have right now we are having. Secondly, before that law comes, this incident of filing multiple complaints at different police stations and court matter going into different courts, like whether this will work parallelly, whether I can go directly file an FIR, and whether there should be, or that FIR should be transferred to first the level 1 redressal and then to level 2, level 3. What will happen? This is the main confusion, and like immediate clarity is required in this matter. Second thing is that you need to give more tips to this self-regulatory body. You are saying that there is the industry level body. Then if a person is dissatisfied, it can go immediately to the next level. No, there should be something should be full and final at that stage only. And if the complainant can prove the merit of his complaint to the next level, then it should escalate to the next level. And so this is my submission.
Okay, Karan, your final point.
I think what has happened, regulation is necessary in a country like India. We are guided by diverse cultures, but I think there has to be some clarity in terms of what is allowed, what is not. Of course, OTT is something which is very new for everyone. It's industry which just started about 5 years back, with the advent of 4G. I think we learned with time, and once we build a clarity in terms of what's allowed and what's not, I think things will move to a better rate.
Tanu, your final point of view.
So my final remark would be, Annurag, like you said, it looks like right now the rules are in a work in progress mode. My view on this would just be that any form of legislating should not be, should not adopt a trial and error method. The government definitely needs to engage with everybody who's a stakeholder, including the bodies, the self-regulatory bodies that have been formed. I think everybody needs to come together, understand the entire ecosystem. Regulations are typically always behind technology, and that we all understand. But as long as there is a genuine effort to understand the ecosystem and come up with an effective legislation, I think ultimately we should come up with something which works for everybody in the ecosystem and is balanced.
Okay, Vishnu, you have the last laugh.
Okay, so I heard Karan's very interesting point on 5 and 10 year projections. I have a very interesting flip side take to this, and I believe that just like the arbitration industry has grown into where private players are offering arbitral services and their reputation is exactly what's on the line and they're getting more business. I think if OTT percentages increase in terms of consumption, you're looking at more self-regulatory bodies, you're looking at bodies vying for complaints and grievance redressals based solely on their reputation to resolve the complaints and avoid escalation to the oversight mechanism. So you're looking at tremendous opportunity there. I totally agree with Tanu that greater engagement is definitely the need of the hour. I think the engagement did lack. There is a lacunae which today people like us are now starting to discuss. And for me, the final word is I'm waiting with bated breath to what the courts say insofar as the social media intermediaries go. I think there will be some kind of guidance which courts then might be tempted to apply, or even self-regulatory bodies and oversight mechanisms may be tempted to follow insofar as OTT platforms are concerned. So just to end with your words, a work in progress. Let's hope things are positive and not riddled with technical inconsistencies and bureaucratic oversight.
Thank you so much to each one of you and my colleagues Anisha and Krishnendra. I also want to announce the BW Legal World dialogue or conversation or the webinar for next Saturday. We talk about insolvency proceedings against personal guarantees under IBC, reflections, ramifications, and the way forward. We have a really power-packed panel. We have Justice Kurian Joseph. We have Dr. UK Chaudhary, who in the NCLT and NCLAT is a giant. We have Mr. Mukesh Bhatani, and we have the immediate past chairman of SBI, Mr. Rajneesh Kumar, joining us in a conversation on this very important issue, on the issue of the personal guarantees. And as I was talking to UKC, he said that it's not implementable, and he gave me statute after statute and examples after examples. So we look at its implementation, whether these are enforceable, whether it goes against the concept of limited liability, what does it mean for banks, what does it mean for promoters, what does it mean for intermediaries. That's next Saturday, 12 to 1. Look forward to joining all of you again at this BW Legal World webinar. 12 to 1 every Saturday. We have the Saturday solution, as we call this webinar. It is about solutions, it's about way forward. So thank you again, Vishnu, Tanu, Petal, Karan, Anamika, for joining in, and thank you, Zamir, for your inputs. Stay safe, stay healthy. Thank you, Anisha, for helping me prepare for this.
Thanks, everybody.
And we look forward to being in continued dialogue and conversation, so that to all the stakeholders, we can take everyone's viewpoint into consideration, and we look forward to more nuanced viewpoints from each one. Thank you. Stay safe. Have a good weekend.